So we had studied up to order 3940 and we had reached up to interlocutory orders. That is the orders and injunctions that can be passed in the meantime. Suit pending ଥିଲା ବେଳେ କଣ କଣ order pass କରାହଉଥିଲା ଆମେ ଦେଖିଲେ ତ ଏଟା those were optional. Those three things that we discussed, that is order 38, 39 and 40, those were optionals. Now coming to another almost compulsory stage, which is jaha document, whichever documents are in the possession or power of the parties, those are to be produced, and how those will be produced, and if they can be impounded, if they can be returned to the parties, all of the provisions that are dealt under CPC, we'll discuss them one by one. Order 13, Rule 1 says original documents will be produced. So it says that the parties who are in power or possession of the documentary evidences, they shall produce it before the settlement of issues or on the settlement of issues. ଏଠି ଗୋଟେ ପ୍ରୋଭିଜନ ଆଗ କଲା ଯାହା ଆପଣଙ୍କର ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ଅଛି ଆପଣ ଦେବେ କେବେଠୁ କେବେ ପର୍ଯ୍ୟନ୍ତ ଦେଇପାରିବେ ସେଟଲମେଣ୍ଟ ଅଫ ଇସ୍ୟୁଜ ପର୍ଯ୍ୟନ୍ତ ଦେଇପାରିବେ କାହିଁକିନା ଇସ୍ୟୁ ସେଟଲମେଣ୍ଟ ଆଗରୁ the court has to also see all the documents that have been produced by the parties and accordingly the issues will be settled. So before settlement of issues, all the documents, all the documentary evidences, those are there in the power or possession of the parties, they are to be produced, but subject to the condition that the copies thereof have been produced along with the plaint or written statement. Because while studying plaint and written statement, we had studied that while submitting the plaint or written statement, as the case may be, whatever documents you are relying on, you have to supply a copy of the same. So if you do not give the copy, then you can't produce the original now. So before settlement of issues, you have to produce the original, but subject to the condition that you have given the copies along with the plaint or the written statement. Now, when you give the document, court has a duty to receive them. Court will receive them and keep them in the record if it has been accompanied by the accurate list in the prescribed form that has been prescribed by the High Court. Then the court has to receive the same. Court should also receive karibo, but ଏଇ ଯୋଉ କହିଲା ଯେ parties are required to produce all documentary evidence in their power on or before settlement of issues, ମାନେ settlement of issues ପରେ ଯାହା documents ତାଙ୍କ power ରେ ଅଛି ସେମାନେ produce କରିପାରିବେନି, ଯାହାର copy ସେମାନେ ଦେଇଥିବେ ସେଟା କରିପାରିବେ ସବୁବେଳେ ମାନେ କରୁଥିଲେ, but ଯଦି ତା ପରେ କରିପାରିବେନି ବୋଲି କହୁଛି, but କୋଉ document ଆପଣ produce କରିପାରିବେ even after settlement of issues, those are if those documents are required or produced for cross examination of the witness of the opposite party. ताମାନେ ଗୋଟେ ପାର୍ଟି ଆସିକି ଅଦର ପାର୍ଟିର ୱିଟନେସ୍ ଆସିକି ସେଠି ସିଏ ଏକ୍ସାମିନେସନ ତାର ଚାଲିଲା ବେଳକୁ ସିଏ କିଛି ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା, and to cross examine him you are showing him a document. So ସିଏ ସପୋଜ ଏକ୍ସାମିନେସନ ରେ ତାର କହିଲା ଅଦର ପାର୍ଟିର ୱିଟନେସ୍ that ନା ମୁଁ ଏମିତିଆ କିଛି ସେଲ୍ ଡିଡ୍ ଏଣ୍ଟର ମାନେ କରିନି or ସେଲ୍ ଡିଡ୍ କେବେ କିଛି ମୁଁ ଏମିତିଆ ବନେଇନି. So in that case you show that sale deed and ask that ଏଇ ଯୋଉ sale deed ଟା then କିଏ ବନେଇଛି ଆପଣ ବନେଇ ନାହାନ୍ତି. So in that case to cross examine the witness of the opposite party you can very well produce a document even after settlement of issues. Again, what can be produced even after settlement of issues? Those are the documents which are handed over to the witness to refresh the memory. ତାମାନେ ଗୋଟେ ଡକ୍ଟରଟେ ସାକ୍ଷୀ କରୁଛନ୍ତି, ଡକ୍ଟରଟେ ସାକ୍ଷୀ କଲା ବେଳକୁ ସିଏ ତାର ୟୁଜୁଆଲ କୋର୍ସରେ ଦେଖିଥିଲା ତାର ମେମୋରି ସବୁ କଣ ମନେ ରହିବ ତାର, ତ ତାର ମେମୋରି ରିଫ୍ରେଶ କରିବା ପାଇଁ ଯଦି ଆପଣ ତାକୁ ଦେଖଉଛନ୍ତି, in that case that is also fine, you can do so. So that is what rule 1 says, that on or before settlement of issues you have to produce all the documentary evidences that are there in your power. The exceptions are that you can produce a document for cross examination of the witness of the opposite party, or you can produce a document which are handed over to the witnesses, to your own witness, to refresh the memory. Rule 2 has been repealed. Coming to rule 3, that is rejection. Court, if it finds that the documents that you have produced are irrelevant or otherwise inadmissible, देखिला कि सेटा रिलेवेंट नुह किछि रिलेवेंसी नहीं तार केस सहित किछि रिलेवेंस नहीं तार सूट सहित और इनएडमिसिबल suppose according to the evidence act those are inadmissible जदि कोर्ट एटा देखिला then it can very well reject the documents. Now coming to rule 4 जे जते बेले जदि रिजेक्ट करदेला जदि रिजेक्ट न कला और एडमिट कला कोर्ट then what the court has to do documents जोटा आपण प्रोड्यूस कले if the court admits them then he shall endorse thereon following things तार माने सेठी लिखिबो जे नंबर ऑफ द सूट पके टाइटल ऑफ द सूट पके वर्सेस प्लेंटिफ रो ना वर्सेस डिफेंडेंट रो ना नेम ऑफ द पर्सन प्रोड्यूसिंग इट किए से डॉक्यूमेंट प्रोड्यूस कला सेटा भी सेठी गोटे एंडोर्समेंट करा हबो date when it was produced who date reproduce hela statement to the effect that it was admitted so in fact it was admitted you have to make a statement to that effect as well apare sign and initial of the judge so you have to put the sign and initial of the judge as well next is ei panchta jinsa mandatory you have to endorse on documents which are to be admitted then again in a special case if the document is an entry in a book account or record and copy is substituted for the original then endorsement of such particulars that a copy has been given and substituted for the original an endorsement to that effect has also to be made is also to be made so it is saying rule 5 रे हमें पढिबा नेक्स्ट रूल रे अछि जे जेतल गोटे बुक थिबो किबा अकाउंट्स थिबो किबा रेकॉर्ड थिबो लेटर बुक थिबो कि शॉप बुक थिबो in that case those are maintained habitually and you can't keep that book forever so in that case सेठी कोन हुए कोर्ट को जे आपण गोटे कॉपी दे दियंतु तार आपण ओरिजिनल टा नै जानतु and you use it in your due course तो गोटे लाइब्रेरी रो गोटे रजिस्टर टा मेंटेन की से बुक टा फेरै छिना नै और से दिन सेठी एंटर हेछि ना गोटे सिक्योरिटी गार्ड रो गेट कीपर रो जो येटा रजिस्ट्रीटा whether who has come to the place to ensure that if anything has been done then all those documents जोटा को जहार कॉपी सब्स्टिट्यूटेड हेछि ओरिजिनल थारे ताले सेठी to that effect also an endorsement has to be made that in the due course a copy has been substituted for the original now coming to rule 5 rule 5 रे कहला rule 4 रे कहला कि नॉर्मल जिंस गुडा करे नॉर्मल डॉक्यूमेंट्स रे कोन एंडोर्समेंट हबो rule 5 रे कहला जे जदी सी यो गुडा copies of admitted entries in books accounts etc then in that case what endorsements will be made on that it is talking about that it is saying that if it is an entry in a book account or record then the copy of such entry in book account or record to be furnished जदि गोटे आपण एंट्री टाकू जे एई डेट रे एई डे रे से सेठी एंटर करथिला सेई पार्ट टाको आपण डॉक्यूमेंट टाको प्रोड्यूस करिया चाहू तो इन दैट केस आपण तार कॉपी गोटे दे देबे एंड जदि सेटा पब्लिक रिकॉर्ड हितिबो और गोटे एमजे जिंस हितिबो जोटा कि पार्टी रो पावर रे नथिबो देन सेठी कोर्ट कोन कहबो दैट सच पार्टी has to produce the same court taku कहि डायरेक्ट कर परिबो that such party has to produce the same and the copy is to be furnished by such party तामाने जहा बिहाफ रे से डॉक्यूमेंट फर्निश करा होजी कोर्ट कैन डायरेक्ट that a copy to be furnished by such party even if it is a public record so सेठी कहि परिबोनी पार्टी जे public record तणु ता कॉपी मु काई देबी no because it is furnished on your behalf now you have to give a copy of the same at your expense so that we can record the public record to its originality or जदि सेटा कोर्ट निजे डाकिची ताले कोर्ट कैन डायरेक्ट that any party might furnish the copy डायरेक्ट कर परिबो कोई पार्टी एना कोर्ट दरकार कहा पे आइदर जण के फेवर रे यूज हितियो कोर्ट देबे देखिबो जे कहा फेवर से डॉक्यूमेंट पब्लिक डॉक्यूमेंट यूज होची तणु तार कॉपीटा ताकू दवा पे कोर्ट कहै तो तापरे कहला जदि once copy has been produced ये जो जहां भी admitted entry in book account record तार कॉपी थरे प्रोड्यूस हे गला then the court will examine it compare it and certify it कोर्ट माने कोन कोर्ट निजे करे नॉर्मली सेरेस्तादार करथि सेरेस्तादार माने कोर्ट रो जे ऑफिसर गोटे थांदी appointed in that behalf now the सेरेस्तादार is called chief administrative officer the chief administrative officer of the court will examine it compare it certify it and then mark the entry and then return the same to the person who has produced. ଯାହାକୁ produce କରାଇ ଯିଏ produce କରିଛି ତାକୁ ଯଦି public record ହେଇଥିବ ତାହେଲେ to such public office ଯୋଉଠୁ ସେଟା ଆସିଥିଲା it will be uh, returned to that public office. Next is if it is rejected. ଆମେ ଏଠି rule 4 rule 5 ରେ ପଢିଲେ ଯେ admitted documents ରେ କଣ endorsement ହଉଛି but rule 3 ରେ reject ବି ହଉଥିଲା. so 1 ସହିତ ଆମେ ପଢିଲେ 4 and 5 କୁ ଯେ 1 ଟା ଯଦି admit ହେଲା ତାହେଲେ 4 5 ରେ କଣ ହଉଛି but ଏବେ 3 ରେ ହେଲା reject ତ 3 ରେ reject ହେଲେ ତା ଉପରେ କଣ endorsements କରାହବ that has been explained in rule 6. Rule 6 says if it is considered inadmissible by the court, then endorsement to be made of the following. Say number karahabo, title karahabo, name of the person producing it karahabo, date when it was produced karahabo, sign or initial of the judge karahabo. So sabu common achi. Kali se jo statement to the effect that it was admitted thila. Rule 4 रे ଆମେ देखुले कोन D रे थिला statement to the effect that it was admitted. Now rule 6 रे statement to the effect that it was rejected. So it is easy, very easy. So endorsement will be made for reflecting the following things. Now coming to rule 7, that if recording of admitted and rejected documents. So it is कोची एबे जे जो admit हला किबा reject हला से जो documents गुडा what will be their status ता कोन recorder part हेबे कि recorder part हेबेनी सेइटा कि तार status टा कोन हबो that is what rule 7 says. Rule 7 says that if the document that has been produced is admitted or a copy has been substituted for the original, again it is admitted, that's why it has copy has been substituted. It is admitted, either admitted or because it is a book of accounts or other record, a copy has been substituted, then such document will form the part of the record. तामाने एबे थरे धरा जी गला थरे admit ही गला परे धरा जीवो सेटा record रो part हो. So then you can't just take the document like that. Once it becomes the part of the record, you can't just take the document just like that. But of course, if it is not admitted, that means if it is rejected, then it is not a part of the record and it will be returned to the party producing. If जो party produce करथिबो ताको return कराइजिबो because it is not a part of the record, so there is no benefit in keeping it. So it will be returned to the party producing it. Now, impounding of documents. Impounding of documents. First हमें पढ़ले जे कोठी हमरो admission केमती होतिला, admission होतिला, production रो admission केमती हला. Now हमें return भी केतले होउची सेटा भी पढ़ले. Now पढ़िबा impounding. Impounding कोन? Impounding word रो बुझा होची impound माने जब्त कर दबा. Or when you seize a particular document, that is impounding of documents. So normally the books, accounts, etc. are to be returned. So books and accounts, for once they are compared with the original or their copy has been given and copy has been substituted for the original. The original is returned. Original टा normally return कराया जाए. जो हमें rule 5 रे rule 7 रे पढ़ले. Rule 5 रे कोन पढ़थिले एटी. Rule 5 रे कहिथिले जे endorsement करइबो, endorsement कला परे examine करिकी compare करिकी certify करिकी ताकू एंट्री करिकी रिटर्न कर दबो. रूल 7 रे भी कहले जदी नॉट एडमिटेड ताहले भी हमें ताकू रिटर्न करथिले. तापरे रूल आउट भी कोन रूल 17 ऑफ ऑर्डर 7. रूल 17 ऑफ ऑर्डर 7 रे भी से कहूची जो शॉप बुक और लेटर बुक एज द केस में भी ताकू जदी प्रोड्यूस करा हबो देन तार कॉपी कोर्ट रो ऑफिसर जे चाहिबो ता कॉपी कंपेयर करिकी कॉपी करिकी ताकू मार्क करिवो and it will be deemed as if it is a copy has been substituted and the original will be returned. So I mean, if you remember order 17 order 7 rule 17 रा मेरा पढ़िथिले. So एई जो rule 5 और rule 7 of this code और rule 17 of order 7 रे जहां भी normally आसे normally ताको return करा. Rule 7 रे जदी inadmissible थिबो return होची. Rule 5 रे जदी books of accounts हे गला compare हे गला return होची. Rule 17 रे सेमती rule 17 of order 7 रे सेमती जदी book shop book थिला letter book थिला तले सोडा भी return होची. In that case, if all these are returned, then if court But if court sees sufficient reason that they shouldn't be returned, then in that case, court is of the opinion that it should in fact be kept because it is required for the just decision of the case, or otherwise as the court decides. Then in that case, the court may impound and keep in custody of an officer of court for any period according to any. That means ଏଠି କୋର୍ଟ କହିବ ଯେ ନାଇଁ ତମକୁ ଏଟା ଫେରେଇବାର ଥିଲା ମତେ, but because I see sufficient reason, I think that it is necessary to be kept for that purpose, I will keep the same and I will impound that document. So seize that document and ସେଟା ଗୋଟେ କୋର୍ଟର ଗୋଟେ ଅଫିସର କଷ୍ଟଡିରେ ରହିବ for such period and according to such condition as the case may be. Now coming to rule 9, return of admitted documents. This is important. This is important in the sense कि अपन थोड़े document दे देले, सेटा थोड़े part of the record ही गला. Can you ever get it back? With once because it is a part of the record now. So it is saying, the rule is saying that if the person is producing the record, whoever that person might be, whether he is a party or not, that is immaterial. If he is producing the record, then he is entitled to get it back. He can get it back, even if it is admitted and has been a part of the record. Then also he is entitled to get it back. And see, DJ produce करछि document ता काहे से पाई परिबन तार document ता से आनी देथिला कोर्ट भी आनी देथिला, तो just because it is a part of the record से पाइबनी, no, he will get it back, but certain conditions are to be satisfied. First is that if there is no appeal provision preferred, there is no appeal provision prescribed for that, then if when the suit is disposed of, suitটা जो थिला जदि डिस्पोज ऑफ हेगला आ ता पई अपील रो प्रोविजन नै ताले ताकू मिल जाई परिबो, जदि से अप्लाई करिवो ताले से पाई परिबो, और जदि टाइम ऑफ अपील एलैप्स करि गलानी, टाइम ऑफ अपील एलैप्स करि गलानी किंतु अपील प्रेफर हे, माने अपील हेडी प्रेफर हे परथांदा किंतु टाइम पळेलानी किंतु से अपील करे, in that case also if he makes an application then he can get back the documents. Third is अपील जो थरे अपील हेई परथांदा, अपील हेला किंतु से अपील टा डिस्पोज ऑफ हेगा, in that case he can also get it back. So ए तीनटा केस रे ताकू मिल जिवो without doing anything. If all these time periods have been complied with, he'll get it. Like जदि अपील नथिबो ताले सूट डिस्पोज हे गेले, जदि अपील थिबो ताहेले आइदर अपील पीरियड एक्सपायर कर गेलानी किंतु अपील प्रेफर हेनी किंबा अपील प्रेफर हेजी and it has been disposed of. Also it can be gotten back earlier as well. आपण कहबे जे तीनटा पीरियड न हेले कोन तक पाई परिबनी, तो आगुर जो दरकार हम सपोज मु मोर एबे 10th 12th रो LLB रो सर्टिफिकेट दे देछि, now I am selected as a judicial officer, so I need to get it back for my document verification. So whether can I get it back or not? So the rule says yes, you will get it back if you are a party. Then for that, if you are a party, you have to deliver a certified copy of this. So आपण तारा certified copy देबे, जदि आपण गोटे party of the suit, then in that case you have to give a certified copy. आ जदि आपण party नुह अलगा गोटे लोक other than a party to the suit, then ordinary copy देले भी चलिबो, but it should be examined, compared and certified according to order 7 rule 17 clause 2. से order 7 rule 17 रे देछि जे ओरिजिनल जदि गोटे प्रोड्यूस करिवो तारो हमें कोर्ट ऑफिसर चाहिले ताको कंपेयर करिकि कॉपी करिकि कंपेयर करिकि एग्जामिन करिकि गोटे कॉपी ताको देई परिबे आ डेटा को सर्टिफाइड कॉपी भड़िया ताको धरा, तो इन दैट केस सर्टिफाइड कॉपी न हेले भी से ऑर्डिनरी कॉपी देई परिबो जदि एमकेआ टाइप रो से सर्टिफाई करिथिबो ऑर्डर 7 रूल 17 क्लॉज 2. पार्टी जदि हेतिबो ताले ताको पार्टी टू दिस उठेतो ताले ताको सर्टिफाइड कॉपी देबाको मस्ट, बट जदि पार्टी न हेकी अलगा के पर्सन अछि देन ऑर्डिनरी कॉपी देले भी इट विल बी सफिशिएंट. सेठी से कोन करिवो एमकेआ कॉपी जदि थिबो ताले से ऑफिसर को देई देबो and he will substitute the same in place of the original officer माने कोन कोर्ट रो ऑफिसर से सीईओ सेरसुदर chief administrative officer, and he will substitute the copy, certified copy or compared copy as the case may be in place of the original, and तापरे ताकू ते डॉक्यूमेंट टा रिटर्न करा जाई पारे. एक्सेप्शन अछि जे केते बेले रिटर्न करा जीवनी डॉक्यूमेंट, फर्स्ट होची जेते बेले हेडा इंपाउंड हे छि, यदि कोर्ट हेडा थोड़ी इंपाउंड कर देछि आउ फेरे करी जे परंतु कोर्ट से इम्पाउंडिंग टा उठिबनी से पर्यंत फेरिवार क्वेश्चन नहीं आपनकर जते इंपोर्टेंट नहीं था आपण पाइ और इफ डॉक्यूमेंट हैज बिकम void or useless by force of a document ता माने आपण गोटे सेल डीड टे देथिले किंतु से सेल डीड टा को एबे कोर्ट डिक्री करके कैंसिल कर दे इट इज नॉट ए वैलिड सेल डीड बिकॉज़ तादरे कोerशन हेची और फ्रॉड हेची फ्रॉड रे ऑप्टेन हेची और समथिंग मिसरिप्रेजेंटेशन हेची और सेंति करके डिक्री पूरा वैलिड डिक्री रो अकॉर्डिंग टू द डिक्री द डॉक्यूमेंट हैज बिकम void then in that case it will be not returned as well or useless heglani mane because of the decree now it has been rendered useless एमती किछि हेगलानी जेते से डॉक्यूमेंट रा किछि यूज इन केना गोटे सर्टिफिकेट सपोज थिला बट एबे कोर्ट रा डिक्री कहूची जे सेई ईयर रे जो माने सब पास हेतिले समान को सेटा सब एक्चुअली भूल हेतिला तनु तांका पय री एग्जामिनेशन so in that case the document has become useless so in that case it will not be returned नेक्स्ट इज केतले दिया हबनी जदि से कॉपी जहा दबा कथा जो हम पढिथिले जे सर्टिफाइड कॉपी दबा पार्टी हेतिले किबा नॉर्मल कॉपी दबा जदि अदर देन पार्टी हेतिबो इफ ही इज नॉट फर्निशिंग ए कॉपी देन इट विल नॉट बी फोर्थ इज जदि टाइम नॉट एलाउड जदि कॉपी कथा त आसुची जेतले अर्लियर मागुची बट जदि सूट ता डिस्पोज हेइनी देन ताको मिल परिवनी जदि अपील प्रेफर हेइ जाईची आउ अपील ता डिस्पोज हेइनी ताले मिल परिवनी किंबा जदि अपील प्रिफर हेइनी किंतु अपील रो टाइम स्टिल अछि then in that case also you will not get it. So these are the exceptions. Now coming to rule 10 ebe padhiba hame inspection of records. So this is also a value mane important rule in the sense that many times there are applications made by parties that say kotru you have please it is a prayer to call for the original record from that or call for the original record of this suit or this GR so ethi apana normally करंदी जे सेई कोर्ट रे सेई केस रो रेकॉर्ड रे जहा एविडेंस अछि दैट इज नेसेसरी और तार डॉक्यूमेंट्स गुडा नेसेसरी और तादर जहा डिस्कशन अछि दैट इज नेसेसरी so in that case the parties can apply for the same and court जदि चाहिबो on the application of a party or suo motu can ask for or can call for the records from its own court or from any other court to be produced before it होई परिबो जे सपोज एबे सब जज अछंती सिए तांको देखिले जे आ गोटे जहा मुनिसिफ कोर्ट रे गोटे रेकॉर्ड पेंडिंग हेची जोडा दरकार तांकर जस्ट डिसीजन पे दरकार बोली से ही इज ऑफ द ओपिनियन देन ही कैन कॉल फॉर द सेम और एप्लीकेशन देला पार्टी जे एटा दरकार एटा पार्टी ए रेकॉर्ड को डाकिया दरकार माने आनिया दरकार आ इंस्पेक्ट करिया दरकार को ताले कोर्ट कैन डू सो बट ऑफ कोर्स जदि पार्टी अप्लाई करूची कोर्ट अप्लाई करले तो से कोर्ट जदि चाहिबो तो आपे आपे करि परिबो बट जदि पार्टी अप्लाई करूची ताले पार्टी हैज टू गिव एन एफिडेविट शोइंग हाउ इट इज नेसेसरी पार्टी को देखिया पड़िबो हाउ इट इज नेसेसरी हाउ हाउ एटा भी देखिया पड़िबो दैट ही कुड नॉट ऑब्टेन इट विदाउट रीजनेबल डिले और एक्सपेंस तमाने गोटे बहुत दूर जगह रे थिला तम सब बहुत खर्च होइथांदा आनिया पई सितमे से कोर्ट को कहबो जे आपण एटिके मगे और बहुत टाइम लागिथांदा ताकू सितमे कोर्ट को कहबो जे आपण मगे इट कैन बी डन आउ जदि सेटा भी नहीं ताले एटलीस्ट एतिके तो देखिया कथा जे ओरिजिनल प्रोडक्शन टा इज नेसेसरी कॉपी देले इट विल नॉट सफाइस you have to inspect the original in order to know the know a certain thing if that is also proved then the court can call for a record but etik apnu munde rakhiya padibo just because you can call for a record you can't use it as an evidence if it is otherwise inadmissible according to the evidence act's provision so if it is otherwise inadmissible then you can't use it as evidence just because you could call for the records that is what rule 10. Now coming to rule 11, that is the last rule, which talks about the fact that if there is a material object, so for that matter, jodi gote material object achi and say material object ra production darkar, then how it will be done? It is saying that such preceding rules, जोड़ा हमें documents पे जहाँ rules पढ़िले जे documents रा production, inspection, impounding, जहाँ पे जो rules उड़ा थिला, such preceding rules shall have mutatis mutandis application माने जदि गोटे material object what is a material object now material object माने document तो होची गोटे it's a document it's a we know कि हमें देखिले ताकरू it is a it is showing something, it is showing a fact, it is a representation of a fact. But material object can be anything. A gun, the production of gun is necessary for just decision of a case, or the production of a particular seized item is necessary. That is a material object. So for that item, ଯଦି ସେଟା ବି production ହଉଛି, then ତାର rule ଗୁଡା କଣ କହୁଛି ଯେ ଯାହା documents କୁ rule application ହଉଥିଲା, ଏ ଯୋଉଟା ପଢିଲେ rule 1 ରୁ 10 ପର୍ଯ୍ୟନ୍ତ, rule 11 ରେ କହିଦେଲା ଯେ material object କୁ ଯଦି ଆପଣ production କରିବେ, then it will have mutant application for the same as well. So this in a nutshell completes our discussion on order 13. I hope it is clear to you. It was relatively easy because those were rules, but nevertheless you know it. Order 13, rule 9, 10, these are very important because many a times it is used practically, because you have to get the documents that you have produced it before the court. You will need it. So how you will get it back? These are then given. If there is any doubt, please put it right now. Yes, Pritiman, what is the doubt?
सर नमस्कार सर, जो ऑर्डर 13 रूल 1 रे कहला सर, सबमिशन ऑफ डॉक्यूमेंट सर सेटा जेरॉक्स कॉपी ना ओरिजिनल कॉपी माने सॉफ्ट कॉपी माने और डॉक्यूमेंट हैंड ओवर करिया पड़े कोर्ट रे?
कोड कहला सबमिशन ऑफ डॉक्यूमेंट्स कहला जेरॉक्स कॉपी कथा कोड आपन आसला?
नहीं सर, मो माने फॉर एग्जांपल जानिया चाहूँ कोर्ट रे जब सबमिट करिवे जो कॉपी जो डॉक्यूमेंट जो क्वेश्चन तार माने घर रो जो ओरिजिनल ना माने
Today you
जेरॉक्स
have
कॉपी
to submit in original. You have to remember. ସେତେ ତ କହିଲା ନା ଯେ ଫର୍ଷ୍ଟ କଥା ହିଁ ସେଇଟା, the you have to ଲେଖିଛି the all the documentary evidences in original. You can't produce a xerox copy. ଆପଣ ତ ଫର୍ଷ୍ଟ ଲାଇନ ଟା ହିଁ ତ ଲେଖା ହେଇଛି original. ଆପଣ original ଛଡା କେବେ xerox copy produce କରିପାରିବେ?
सर जे तो आमे केस फाइल करे जाते माने माने लोन
In absence of primary evidence, secondary evidence is allowed. ଆମେ evidence ରେ ପଢିଛେ evidence act ରେ, ଯଦି absence of primary ଆପଣ prove କରିଦେଲେ କି ଯେ ସେ primary evidence is absent altogether, ଆପଣଙ୍କର cell deed ଟା ହେଇଥିଲା original cell deed, ସେଟା that has been destroyed in a house fire. Now it is not possible to produce it. ଗୋଟେ fire ରେ destroy ହେଇଗଲା, earthquake ହେଲା ଆଉ ସେଟା destroy ହେଇଗଲା, ଭୁଜରେ ଆପଣ ରହୁଥିଲେ, earthquake ହେଲା, that has been already destroyed. Now you are not in a power or position to produce it. That is secondary. So ସେଇଠି secondary evidence ଟାକୁ primary ଭଳିଆ treat କରିପାରୁଛେ evidence act, ଆମେ ଯେତେବେଳେ evidence act ପଢିବା ଜାଣିବା. But normally you have to produce all the original documents.
ओके सर.
Anyone else? Yes, Dharitri ma'am. What's the doubt?
Sir, namaskar. Sir, what is the difference between certified copy and ordinary copy?
See, certified copy is a copy which is certified copy जोटाको आपण पूरा अप्लाई करिकि नेइथिबे. गोटे अछि आपनकर कॉपी सेक्शन अछि. कॉपी सेक्शन रे आपण अप्लाई करिकि जो राउचंदी सेटा सर्टिफाइड. नॉर्मली सब डिपार्टमेंट रे थाए जे सेमाने सर्टिफाइड कॉपीज देबे, जे कोडा होची सर्टिफाइड कॉपीज केमति कोडा को प्रोविजन फॉलो कले दैट विल बी डीम्ड एज सर्टिफाइड कॉपी. सब ये रे थाए. तो सर्टिफाइड कॉपीज दैट द अथॉरिटी विल सर्टिफाई that this is the true copy thereof and I certified it to be genuine. That is a certified copy. But the normal copy kochi that has not been certified by the authority, but because it has been compared by an officer of the court and the original has been returned, now that copy, even if it is not a certified copy per se, it is deemed to be given the status of a certified copy, and even if it is it is a normal copy, ତାକୁ ଆମେ allow କରିବୁ. But ଏତିକି difference, certified copy ଆପଣଙ୍କୁ must produce କରିବାକୁ ପଡିବ if you are a party to the suit, but if you are not a party to the suit, then you can get away with it by just producing a normal.
Sir, layman କେମିତି ଜାଣିବ କି ଏଟା certified copy କି ଏଟା ordinary copy?
କାହିଁକିନା ସେଥିରେ ଲେଖା ହେଇଥିବ ପୁରା certified copy ରେ ଲେଖା ହେଇଥିବ this is a certified copy.
କୋର୍ଟ ର ଷ୍ଟାମ୍ପ ଥିବ କି ମାନେ କିଛି ଗୋଟେ
କୋର୍ଟ ରୁ ତ ଖାଲି certified copy ଆଣିବା ଆସିବନି. ଏବେ ସପୋଜ ମୁଁ ଏନା ସେକ୍ରେଟାରିଏଟ ରୁ ଗୋଟେ କପି ଆଣିବି, ବୁଝିପାରୁଛନ୍ତି, ସେକ୍ରେଟାରିଏଟ ରୁ ଗୋଟେ ଜିନିଷର ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ ର କପି ଦରକାର, ତ ସେଠି ସେକ୍ରେଟାରିଏଟ ର ଯାହା କପିଂ ସେକ୍ସନ ଥିବ ସିଏ ଦେବେ, और ଗୋଟେ आरटीआई ଆପ୍ଲିକେସନ ର ଗୋଟେ ତାର ଗୋଟେ କଣ କପି ଟେ ଆଣିବି, so ସେମାନେ ସାର୍ଟିଫାଇଡ ଦେବେ. ତ ଯିଏ ସାର୍ଟିଫାଇଡ ଦବ, an authority must certify that it is a certified copy.
ଆଜ୍ଞା
according to the rules there.
ଆଜ୍ଞା ଧନ୍ୟବାଦ।
Anyone else? If not, we'll take some introduction. Please, someone introduce yourself. Who are we meeting first? Who are we meeting first? Arpita Mahapatra, have you been introduced?
No, sir.
Please.
Namaskar, sir. I'm Arpita Mehta, and I have completed my 5-year integrated course from University Law College, and now I am preparing for the judiciary.
Okay, great. Great. Anvesha Mahanta, have you been introduced?
No, sir. I am Anvesha Mohanta. I have completed my 5 years BA LLB from Madhusudan Law College, and I have passed out in 2021. Now I am pursuing my LL.M from Marbanj Law College in criminal law.
Okay, you're doing your LLM. So you are from Baripada?
No, sir. I am from Karanjia in Marbanj district.
Karanjia. Okay, Karanjia. Karanjia. Great. Hmm. Who else? Trinath Sahu, have you been introduced? Trinath Sahu?
Yes, sir. Introduced.
Yes, we
I
have
am
been.
from ULP.
Yes. Trinath Sahu, we have been introduced. Vandana Sharma, ma'am, have you been introduced?
No, sir. I recently joined your group. I came across this in Instagram. Uh,
Oh,
I'm
okay.
working with Kids School of Law.
Okay. Okay, ma'am.
Yeah,
You're working with
I
Kids School
did.
of Law as in you're a teacher?
No. I'm into administration, assistant
Okay.
administrative officer. I did my
Oh,
3 years LLB course from Capital Law College.
that's great. That's great, man.
Now
What do
I'm
you
preparing for judiciary.
Oh, you are appearing for judiciary? That's great. Nice meeting you.
Thank you so much for this platform. It's actually really helpful.
I'm glad that it can help you, man.
God bless you.
Thank you so much. Who else? Snigdha? Snigdha, have you been introduced?
Good evening, sir. Sir, I've
Yes,
already been attending your classes.
yes.
Yes, yeah.
Yes,
This is
yes, I
not the
remember.
first time. Well, I would still go on to introduce myself. I've
Yes,
completed my both my graduation and masters from University Law College. 2019 graduation and 2022, 21, my master's degree, and appearing for judiciary as of now.
right. I can recollect once you introduce yourself once again. But the problem with virtual classes is that because we do not see your faces, it
Yeah,
gets very difficult to remember your names
I
and
agree,
keep
sir.
that in mind.
I agree with you. Thank you so
No,
much, sir.
no issues. Uh, who else? Who else? Who else is not introduced? Nirmala Yadav. Yes, I think we'll introduce. Yes, we were introduced. Sonu Swarna. Sonu Swarna. Please introduce yourself. She left. Okay. Who else? Subecha Patnaik.
Sir, I have already introduced myself.
Yes, we have. Please introduce yourself again so that I'll remember.
Sir, I am in second semester from the law college.
Okay.
Good evening, sir. This is Archana Pradhan, sir. I have not been introduced, sir.
Yes, please introduce yourself. That is good.
Hi, sir. Hi, sir. Sir, currently I am pursuing integrated law from the Kid School of Law, sir. I'm in fourth year, sir.
That's great.
Yes, sir.
So
Nice
you
to meet
you
you,
plan
sir.
to join judiciary as well?
No, sir. Still, I do not know what to do. I'm just figuring out. So let's see, sir.
You take your time. Take your time.
Yes, sir.
Everyone
Yes.
has their own pace.
Yes, sir.
Okay,
Thank you,
great.
sir. Good
No,
to know it.
welcome. Who else is there? Who else is there? Okay, I think we have been introduced. So we'll end the session here and we'll take the next session on Monday, which will be TP Act. And before that, please do not forget there is an exam on Sunday. So Pritiman has a doubt. Pritiman has a doubt. What is the doubt, Pritiman?
No, sir. Monday ro man sir TPS na CPC auto continue agol botte.
No, Monday TPI. So we are taking 1 week CPC, 1 week TP. No. So
Okay.
I
My
intend
section
to
40,
complete one of them soon so that we'll take something more interesting like IPC or something. I know a lot
CRPC,
of
sir.
people will be
CRPC,
CRPC. We have
sir.
already discussed one actually.
Sir,
So
can you
we'll
send the
discuss it
video?
nevertheless. But I want to take IPC after this.
Yes, sir. So, sir,
Yeah.
after section 40 or not, will be in TP. Section 40 for to pade, sir.
In the exam section 40 TP Act, and till the order 40 that we discussed in CPC,
Yes.
those will be the course for the exam on Sunday.
Okay. Thank you, sir.
Welcome. Trinath, what is the doubt?
ସାର୍ ଇଞ୍ଜେକ୍ସନରୁ କିଛି ଗୋଟେ ପଚାରିପାରିବି?
Yes, you may.
ଇଞ୍ଜେକ୍ସନ ଯୋଉ ରୁଲ୍ 1 ର ସେଥିରେ ଯୋଉ ପଏଣ୍ଟ ବି ରେ କହିଥିଲା ଯେ the defendant threatens or intends to remove or dispose of his property, ତ ଏଥିରେ ଯୋଉ his property କହିଲା, ଏଟା ଯୋଉ ପ୍ରପର୍ଟିଟା ସୁଟ୍ ରେ ନଥିବ ସେଟା ବି ଯଦି ସେ ରିମୁଭ୍ କି ଡିସ୍ପୋଜ କରିବାକୁ ଚାହୁଁଥିବ ସେଥିରେ ବି କଣ ଟେମ୍ପୋରାରୀ ଇଞ୍ଜେକ୍ସନ କରିବ?
ନାଇଁ ବଟ୍ ଆପଣ ସେଟାକୁ ଦେଖନ୍ତୁ ନା 39(1)(2) ରେ କଣ କହିଛି କୁହନ୍ତୁ। Let's go to the 39. Yes, here it is. Order 39, Rule 1A, B.
B, sir.
But it is said that no, if it is with a view to defraud the creditors, so
Sure.
nijo property भी कले भी चढ़िबो if it is with the intention of defrauding the creditors, because se जानिछि जे मोर एते एबे credit अछि, if I don't dispose of the same, then probably if a decree is passed, my properties will be attached and I'll be liable to pay. So for the same, to avoid the same, before the court passes a decree, in order to defraud the creditors, I am disposing of my own property, even if it has no relation with the suit. Then also, my intention is to defraud the creditors, and it will be done because so that may be prevented as well.
ସାର୍ ଟେମ୍ପୋରାରୀ ଇଞ୍ଜେକ୍ସନ ଟା ଗୋଟେ ଇଣ୍ଟରିମ୍ ରେମିଡିଆଲ ଅର୍ଡର ନା?
Yes, it is.
ସାର୍ ଯଦି ଗୋଟେ ମାନେ ସୁଟ୍ ପେଣ୍ଡେନ୍ସି ଥିଲା ବେଳେ ହିଁ ସେଟା ପାସ୍ କରା ହୁଏ?
Of course, suit pending थिला बेले suit तो dispose हो जाइथिबो ताले आपण कोन पास करिवे, माने interim injunction केमति करिवे आपण परिबेनी?
ଯୋଉ କିଛିଟା କେସ୍ ରେ ମାନେ ସୁଟ୍ ହିଁ କିଛି ନଥିବ, ତାଙ୍କର କିଛି ଗୋଟେ ମାନେ ମଡେଇ କରୁଥିବେ, ସେ ଯୋଉ ତାଙ୍କୁ ମାନେ ସେଠି ଗୋଟେ ଇଞ୍ଜେକ୍ସନ ପାଇଁ ଯୋଉ ଆପ୍ଲାଏ କରା ହୁଏ ସେଟା କୋଉଥିରେ ହୁଏ ତାହେଲେ?
ମାନେ ସୁଟ୍ ନ ଥାଇ କି injunction ହବ?
ହଁ, ସୁଟ୍ ଆଗରୁ କିଛି ନଥିବ।
ନାଇଁ ଆପଣ ତା ପାଇଁ ବି ସୁଟ୍ କରିକି injunction କରନ୍ତି।
ଆଚ୍ଛା ଆଚ୍ଛା।
ବୁଝିପାରୁଛନ୍ତି, କାହିଁକିନା ଆପଣଙ୍କୁ ଗୋଟେ ପରମାନେଣ୍ଟ ଇଞ୍ଜେକ୍ସନ ପ୍ରେୟାର କରିବାକୁ ପଡିବ, ତାପରେ ଆପଣ ତା ଦେହରେ ଟେମ୍ପୋରାରୀ ଇଞ୍ଜେକ୍ସନ କରିବେ। ପରମାନେଣ୍ଟ ଇଞ୍ଜେକ୍ସନ ଗୋଟେ ସୁଟ୍ ରେ କରିବେ, ସବୁବେଳେ ଆପଣଙ୍କୁ ଖାଲି ଇଞ୍ଜେକ୍ସନ ହିଁ ଦରକାର, ବୁଝିପାରୁଛନ୍ତି। then in that case also you make a suit for permanent injunction, and then in that you make an order, I mean, pray for a temporary injunction order under order 39. ଆପଣ ମେନ୍ ସୁଟ୍ ନଥିଲେ 39 ତ କିଛି ନାହିଁ ନା, ମେନ୍ ସୁଟ୍ ରେ ତ କିଛି ଗୋଟେ ଥିବା ଦରକାର ଯେ କଣ ପାଇଁ ଆପଣ ପ୍ରେ କରିଛନ୍ତି, କଣ ପାଇଁ ସୁଟ୍ ଟା ଅଛି, ତାପରେ ମୁଁ ଟେମ୍ପୋରାରୀ ଇଞ୍ଜେକ୍ସନ। ବୁଝିଲେ, ଖାଲି ଆଇଏ ଯାଇକି ଆପଣ ଗୋଟେ interim application as such cannot be filed. IA should arise out of a suit always.
ठीक है, थैंक यू
Okay,
सर।
chalo, we'll end the session here. We'll meet on Monday. Okay, we'll also meet on Sunday perhaps. I'm planning to discuss the answers on YouTube live, so probably we'll do that. I want to try that YouTube live feature which has just been enabled thanks to all your support, because we are 1100 people strong. So we'll discuss the questions and that will set on Sunday exam on YouTube live. So probably we'll meet on Sunday as well, and then Monday we'll take TP Act once again. Okay, chalo, bye. Have a great night.